U.S. District Judge Sara Ellis has ordered Immigration and Customs Enforcement, better known as ICE, to provide daily briefings to her court. What began as a legal safeguard has now exploded into a national debate about judicial authority and the separation of powers. Is this about enforcing the Constitution, or is a federal judge stepping too far into the executive branch's territory? To understand the controversy, let's start with the case itself. Judge Ellis's order stems from a lawsuit accusing ICE and Border Patrol of civil rights violations during a Chicago enforcement operation called Operation Midway Blitz. Plaintiffs allege agents used excessive force, carried out warrantless arrests, and ignored prior court restrictions on riot control tactics. In earlier rulings, Ellis required agents to wear body cameras and limit tear gas use. But when videos surfaced showing continued violations, she took the unusual step of demanding daily in-person briefings from ICE officials, an extraordinary level of judicial oversight. In her own words, Ellis says the goal isn't to tell ICE how to enforce immigration law, but to make sure those actions stay within constitutional limits. That distinction between compliance and control is at the heart of the fight. Conservative legal voices have slammed Ellis's order as outrageous, warning that it blurs the constitutional line between branches of government. Some have called on the Justice Department to appeal immediately, even filing a writ of mandamus, a rare legal tool to stop a judge who's allegedly overstepped her authority. Their argument: judges can enforce the law, but they can't manage executive agencies. Judges can say what the Constitution requires, one attorney told the Washington Examiner. But they can't become part of the chain of command. Supporters of Ellis disagree. They say she's simply doing her job, holding the government accountable when constitutional rights are at stake. One civil rights lawyer put it bluntly: if agents are breaking court orders, stronger oversight isn't overreach, it's justice. Still, even legal scholars who sympathize with Ellis admit that daily briefings are rare, almost unheard of outside national security emergencies. That makes her decision both bold and legally risky. In court, ICE and Border Patrol officials have shown reluctant cooperation. Gregory Bovino, a Border Patrol commander, appeared before Judge Ellis and agreed to the order with a simple, "Yes, ma'am." Behind that polite response, however, lies real frustration. Officials from the Department of Homeland Security insist they're complying, but they've also defended their agents, calling the protests dangerous and the use of force necessary to restore order. The administration has even questioned some of the videos used in court, arguing they were selectively edited and failed to show the full context. At the same time, the White House and DHS have hinted that Ellis's order crosses traditional judicial boundaries, and they're considering an appeal to rein in what they see as judicial interference in executive operations. Internally, the administration has reassigned local ICE officials and accelerated deportations, moves seen as both compliance and quiet defiance. It's a delicate balancing act, obeying the judge's order while reaffirming executive control. At the heart of this case lies one of America's most fundamental principles: the separation of powers. The legislative branch makes the laws. The executive branch enforces them. And the judiciary interprets them. But what happens when enforcing constitutional rights requires one branch to check another? Courts have the power to issue injunctions and restraining orders to stop unconstitutional actions. They can even require reports to ensure compliance. But traditionally, judges avoid getting involved in day-to-day operations. That's the executive's job. Ellis argues her order falls on the safe side of that line. She's not telling ICE what to do, she's making sure they follow the law while doing it. They see this as a dangerous precedent, one where judges could begin micromanaging law enforcement or even military operations under the banner of oversight. If every federal agency facing a lawsuit had to give daily briefings to a judge, they argue, executive autonomy would collapse. Legally, Ellis has broad discretion to enforce her orders. But politically and constitutionally, her decision pushes the boundaries of judicial authority into uncharted territory. The Department of Justice could appeal the ruling, asking higher courts to decide whether Ellis's daily briefing requirement violates the separation of powers. If upheld, her order could set a new standard for judicial accountability in cases of alleged government abuse. If overturned, it could reaffirm strict limits on what judges can demand from executive agencies. Either way, the stakes go far beyond Chicago. This case could reshape how far federal courts can go in monitoring executive conduct, and how much independence law enforcement agencies truly have when constitutional rights are on the line. Judge Sara Ellis insists her order is about accountability, not control. Her critics say it's about power, not justice. But beneath the headlines lies a deeper question: how can courts protect the Constitution without crossing into the realm of governance? In the end, this isn't just a courtroom drama in Chicago. It's a test of how America's system of checks and balances works when the lines between branches begin to blur. Oversight or overreach? That's for higher courts and history to decide.